Restorers, do you have a definitive plan in place as to what to do when an adjuster throws up a smokescreen in front of you? We've all seen so many instances of this. We've got availability problems. The adjuster responds as, oh, I'm on vacation. And the adjuster comes back and then find out the file has been moved to another adjuster. And then that adjuster will say, well, according to our guidelines, it needs to be handled this way. What can you do about that? Is there a way to cut through that? What if the insurance company is telling the property owner, you can hire whoever you want to do the work, but we may not pay for them, or if you don't use our preferred vendor, it's going to void any warranty you have. There can be a fear that's placed into the minds of these policyholders because of some aggressive tactics that are being taken by insurance adjusters. It seems, according to many restorers who are contacting me, that the problem may actually be getting worse recently. And what about the fact that the insurance companies are paying out billions on Hurricanes Helene and Milton, and now have to pay out billions on the LA fires? Is that going to make a bad problem even worse? What can you do to cut through adjuster smokescreens? If you like this video, if this is something that is important to you or useful for your business, please click the like button and subscribe to this channel so we can continue to bring these items to you. So when an adjuster comes forward and says, you know what, our guidelines say that we need to handle the claim in this certain way, are they allowed to get away with that? Well, as a general rule, the answer lies on whether or not the guideline is reasonable. A lot of us would like to say, you know what, if it's not in the policy, you can't do that. And that may not be accurate 100% of the time. The policy doesn't explain every detail as to how an insurance company is going to adjust a claim or conduct an investigation. The insurance claims handling regulations include a lot of really important information about response times and justification for claims handling decisions. Absolutely get familiar with those. Go onto a browser and put in the name of your state and then put insurance claims handling regulations after it. Run a search. So it'll say Tennessee insurance claims handling regulations, and you'll get to see a list of the laws. These are the rules about how an insurance company is required to investigate a claim and respond to inquiries. And what I think you'll find in most, if not all states, is that the insurance company is required to respond to inquiries regarding the status of the claim, and that responsibility is not limited to inquiries that come just from the policyholder. So that means that in the event that you as the contractor are coming in and you've got a request for information and they fail to respond to you, or they're not providing complete responses or timely responses, you have a right, in my opinion, to be able to tell them, hey, I am a materially interested party in this claim and I'm entitled to a response. Now we want to be careful not to step over the line into public adjusting. What is public adjusting? Well, you want to be aware of the rules in your state as to how that's defined. But in most states, it's basically acting as an advocate for the policyholder for the settlement of a claim. So you're not acting on behalf of the policyholder, you're acting on your own behalf. You're not a public adjuster for the policyholder. So the insurance company is required to implement reasonable guidelines and engage in reasonable conduct with respect to the investigation of the claim, the response to the claim, and the details, the supporting documentation. And we've all heard many times adjusters say to the restorer, give us your supporting documentation for this and for that. Over and over, we hear this a lot. But you know what? If you look at the law, what the law says is it's the insurance company that's really required legally to provide a lot of justification for their decisions. I've never seen a law anywhere in any state that says contractors are required to provide this certain documentation, 1, 2, 3. That doesn't exist. To the contrary, the insurance companies are required to substantiate their claims handling decisions. And if they come back to you with some kind of conclusion without any rationale, there's no analysis, there's no evidence to back it up, they just say, well, we're not going to do this or we're not going to do that. I think it's a good idea for restorers to respond and say, hey, please provide your supporting documentation for this. We need to turn the tide. We need to change the conversation that's taking place out there because there's too much of the insurance companies just drawing information and not enough of them providing information. Now, this is general information. It's not intended as legal advice. You need to talk to a local lawyer who's licensed in the jurisdictions where you perform your work in order to get some answers for your specific situations. Now, a lot of these adjusters, as you know, will say, well, nobody else is charging for this particular line item. First off, I don't know if I believe that. As a matter of fact, I've seen some instances where I know there are several companies charging for an item, yet the insurance company is coming back and saying, nobody else charges for that. I don't know if I believe that. And what supporting documentation do they have for that? What data do they have to show that the Xactimate price is reasonable, for example? They don't have that data. So that's an interesting conversation that you can have with them. But just because nobody else in a market is charging for a particular item does not mean that the insurance company doesn't have to pay for it. What does the insurance company have to pay? What's reasonable? Is it reasonable under the circumstances to charge for a specific item? Reasonable just means fair and sensible. So there's a number of different factors you can look to justify your price. Is this particular thing fair and sensible? Well, it is if you've got a track record of multiple insurance companies paying for it. If you've got line item calculations where you can show how you have calculated your price, particularly if you have followed the basic structure of how Xactimate will assemble the price and then you followed their instructions to adjust the items in there, particularly if your labor wages that you pay are higher than the labor wages that Xactimate presumes that you're paying. You're going to want to make an adjustment for that, and that's what the instructions in the Xactimate user license agreement ask you to do. If you'd like to learn more about how to cut through adjuster smoke screens, please head on over to restorationcrosscheck.com/smokescreens and you'll see some information on there. We've got an upcoming restoration expert briefing where we're going to have a special guest. Mr. Chris Faber will be on with us. He is a very experienced former insurance claims adjuster who is now a PA. He's going to share some good ideas. I got a lot that I want to share with you. On March 6, 2025 at 9 a.m. Pacific time, we'll be presenting the Restoration Expert Briefing on cutting through adjuster smoke screens. That is going to be, again, March 6, 2025, 9 a.m. Pacific time, and you can sign up at restorationcrosscheck.com/smokescreens. We hope to see you then.